Well, thank you very much. As saying here, just to be completely clear, it is being supported by the National Science Foundation on an eager grant. I will say that we have a lot of ground to cover. I will apologize in advance for how quickly I may talk. The saving grace is at 10 o'clock tomorrow morning in the Plaza Room, we are having a security track of which we will also be part of the presentation. So anything we don't cover or get a chance to discuss fully here, we're happy to discuss then. And in fact, David and I will both be here the entire week, both for this meeting and for the Aaron meetings. So for those of you, if anyone doesn't know what RPKI is, and after the traffic on the Nanog listserv that may be vanishingly small, is a way to secure or use PKI encryption to certify origin validation, to avoid the kind of attacks we've seen in the Pakistan and China reroute basically earlier, but even earlier this year we saw the Amazon Route 53 hijack with the DNS, and we also saw the time last month or in August when a bunch of credit card clearing traffic bound for credit card clearing sites was hijacked by a misannouncement through an Indonesian or Malaysian ISP. And so this really is a topic that has been addressed in Nanog before. There's been some question about the perceived differences in adoption rates in the RIPE region and the Yaren region. There are concerns that the barriers are legal and that in fact there is an interest in trying by the NSF to try to crack this nut. Our goals are to really identify what the barriers to adoption are, evaluate them independently with legal expertise that combine with technical expertise, and actually to suggest viable solutions. We did analyze all the issues independently. We've interviewed over 36 of the members of the Nanog community, including different kinds of entities and different kinds of roles. We've been in active discussion with Aaron to try to understand and really inform what we're doing, and we're really grateful for their involvement because I think it's materially improved what we thought. And in fact, we're going to analyze it in absolute terms, but also in relative terms to what's going on in Europe. So the basic, we'll provide some background, including some comparisons to Europe. Then we're going to talk about two phases to RPKI deployment. First, if it's going to work, people who have IP addresses have to sign ROAs. They have to sign certificates saying this is the authoritative place. That is what we call RPKI-based signing in this case, or route ROAs. The second part is people have to, if you sign it, doesn't matter, people have to filter based on those routes. Route origin validation, that's RPKI filtering. We'll talk about them in the reverse order of just introduce them. There are other legal mechanisms we can use to spur deployment and close with next steps. All right. So if you want to see global RPKI deployment, here is some data. As you know, all data is subject to some quibbles. Happy to talk about them in the Q&A. NIST has a monitor that looks at the percentage of the space in IPv4 is signed with ROAs. As you can see, one of the problems we have is a relatively low level of adoption globally, but growing, particularly in the RIPE region, in a promising direction. We have the signature percentage of the IP address space that's signed in IPv4 in the Aaron region being relatively low and unfortunately starting to drop from where it was even a few years ago. Jeff Houston and, well, actually APNIC, and this is through the work of Reuter and others, have something called the ROV Deployment Monitor, where they're actually studying the number of autonomous systems globally who are actually filtering based on this routes. Based on that, the conclusion is, again, overwhelmingly they're in the RIPE, and Aaron, again, is trailing even below past APNIC. On the listserv, as of early this week, Ben Cartwright Cox submitted an analysis, suggested the same, and actually suggested that identified some of the things that RIPE is doing to facilitate adoption. So if you want to think about non-legal barriers, our main charter is the legal barriers. We did talk more generally about all of them, and part of this is just to put it out there so that you know what they are, even though they're not directly going to be the target of what we're talking about. There is a problem of reaching critical mass, and there's a limited demand for RPKI right now. Everyone has limited budgets. You just need to get to the top of the stack. And until we get to that critical mass, it's going to be relatively hard to do. We need the critical mass to happen both on the signing side and the filtering side. And in fact, to facilitate that, we need to ease the tools and make them easier to adopt. And there is some concern right now. The only validator tools are really provided by RIPE NCC. There are some out there by Dragon Software and others that are not robustly supported. There are some efforts to prop them up, but as operators, you understand the importance of having a robust set of options, and that's not entirely the case. So talking about the legal barriers, talking first about the filtering side, Filtering means if you find routes, you can actually see them in one of three states. You can see them as signed valid, you can see them as signed invalid, you can also see them as unsigned. And in fact, filtering requires actually checking what a particular route is and taking an action based on that. And the way we do this is IP address holders, resource holders, sign certificates called ROAs that are put in a repository. The people who would like to filter on it access the repository, find out what the routes are. You can access it directly, or they can access it indirectly through a third-party provider by essentially delegating the task to somebody else to conduct the ROV. Now, what's interesting is what happens, the primary validator software is issued by RIPE NCC. It comes pre-shipped with 4 of the trust anchor locators from 4 of the RIRs preloaded. It does not include the one from Aaron. It does require a separate visit to the Aaron website and a click-rack acceptance of the terms attached to it before it can be used. And one of the questions that's come up is whether this is necessary or a good idea. And what we find has been made clear to us. This is not a huge technical challenge. This is something that I think is well within the capability of everyone in this room. The reality is it does create a certain amount of friction that does slow down some of the adoption. Part of it is the things don't come pre-shipped. Some of the people, such as the validator software or even equipment manufacturers who might be able to build this in a more turnkey, robust sort of way, find that is a bit of an institutional barrier. But the second is if you look at any time you're clicking through a contract, that in turn triggers a certain degree of legal review. A certain degree of legal review is appropriate, and that's part of best practices. But the question is, are there ways we can devise this that might lower the friction? So analyzing this, what we should see is there actually is 2 things going on here which I don't think are always kept separate. The entire community shares an interest in lowering the operational risk of RPKI utilization. And if we lower that absolute risk, it's just better for everybody. There's a separate issue about once we've got that risk within the lowest part where it's really whatsoever the residual risk remains, how we allocate that risk is a separate question. And so one of the points I would like to make during this talk, which is more about the operational side than the legal side, is that lowering operational risk in this world means preparing for very different contingencies. One of them is an RIR RPKI outage, as happened in February 2013 with RIPE NCC. It happened for over 24 hours, and the cache is timed out. In fact, there are other risks that happen, things that can happen with conflicting announcements, which is in the process of being resolved. There are a number of operational issues which are familiar for people who've used PKI systems, and we have established protocols of best practices. In this case, they're embodied in RFC 7115. But in fact, anything at 5 nines, 6 nines, 7 nines reliability faces some risk of downtime. That is normal. I'm sure all of you have dealt with this. Dealing with how to fall back gracefully from those sorts of issues is part of the operational decision of how we manage the risk here. The other part is the legal risk. It is remarkably difficult to assess. RPKI itself, of course, is a new technology. We haven't had lawsuits here, but if you look at similar certificate-based security technologies, there's actually not been a robust set of lawsuits there involving TLS, DNSSEC, and other things. And even if we saw them, as we often say, you've heard on every commercial, past performance does not guarantee future results. Only all things being equal, but things are never equal. So in fact, there's a certain amount of uncertainty that's inherent in this. I don't mean to overstate it in the sense that we have legal uncertainty for car accidents and slip and falls. We work them out over time, but it is costly, and it takes time, and it takes a certain amount of effort. So what are the legal risks here? There is a chance that a provider, someone involved in producing RPKI might be held to what we call products liability. I'm not going to talk about this at great length. In fact, the easiest, it's probably not going to happen if for no other reason it's a service, not a product, and so it falls in a different world. The real issue is really whether someone can be held liable for negligence. We think it's actually a manageable risk, but it can't be eliminated. You can manage it by establishing industry best practices about how failure should be handled, and in fact, having everyone take responsibility for dealing with the failures that are in their control, which is the right way to allocate risk. But also you can have user misuse as a defense. So if someone is not operating it properly, this all can be part of the liability system. But you can't rule out tail risks in this case, particularly on a short-term basis at least, or even potentially a longer-term basis if litigation goes in a certain way. And the US is a famously litigious environment. It can be quite difficult about this. And the interesting question here is, it always potentially is something that can go to a jury. And anytime you go to a jury, it means you have to go through the whole litigation, and you're always rolling the dice on what the result might be. So what you do, the way that this sort of risk is normally handled is by having a contract of some kind in the US system. And the typical way this is handled in a lot of other things in open source software and in DNSSEC and other places is you provide the service on an as-is basis. You disclaim any warranties and say, take it at your own risk and just give adequate disclosure so people know what they're getting. To make that as-is disclaimer effective, you need a contract where everyone signs off, I understand I'm taking it on those terms. And under US law, unless you affirmatively click, you don't have a contract. Having it out as a terms and conditions on the web is not sufficient. So in our analysis, it is justifiable to have some form of an RPA under the US environment, and that is somewhat of a difference from other legal environments, which we think is meaningful. Now that brings us to a second question, which is, what should, if we had to have an RPA, what should the relying party agreement say? And in fact, we've actually had some discussion about how to enable third-party provision, because we've discovered that there are some obstacles in the way that the contract is drafted. I think that what we've been very gratified is discussing this with all the parties involved, whether operators, Aaron, or everybody, is the amount of receptiveness and cooperativeness to really try to get to the same result we're all seek here. And in fact, there are a handful of clauses that we focus on in particular. One's called the Prohibited Conduct Clause, and there's a series about legal liability involving indemnification, arbitration clause, and choice of law clauses, which we'll talk about individually. And we'll have to talk separately about governmental actors and non-governmental actors as we go. So Prohibited Conduct Clause right now prohibits sharing RPKI-derived information in any machine-readable format. Now, this is a problem. Any security system requires a certain amount of ex-post analysis of what's failed and what's succeeded, and in fact, that should be shared in a way that's accessible to other people to allow it to be used properly. So that's one easy problem to solve, and I think that, in fact, one of the great things that we've seen is a great willingness on Aaron's part to consider doing that for non-operational matters. There's a second issue, which is, can it be used for real-time routing? And that in fact, when we see third-party providers who are offering to help with routing, they will probably draw, and this is appropriate, information from a diverse set of sources. First, I think RPKI is a fairly authoritative one and very important one. The idea that every IP address will have a current certificate in the certificate repository, the chance of that happening is not 100%. There'll be some fall off there, and there'll be information in the IRRs of somewhat uneven quality, but still, there's multiple sources of information which a third-party provider, whether people have suggested an IXP, a DNS provider, or perhaps someone doing it as a standalone business, might provide higher quality information to someone. Right now, the Prohibited Conduct Clause for real-time routing is an obstacle for anyone providing those type of services, and one of the things that we're in active discussions with the whole community is to find out how to make that happen, and I've been really gratified again by the fact that this conversation has taken a very constructive tone in ways that I think are extremely positive. So if you want to look as a comparative basis, Aaron has this prohibitive conduct clause that bars sharing of RPKI information in machine-readable format. Two of the RIRs don't have it. AP-NIC doesn't have a specific provision. RIPE NCC does prohibit some form uses, but for a much more limited basis. It's not generally in a machine-readable format. It's basically for marketing purposes. And I think that's of a different order. We have an opportunity here when we think about what Aaron's prohibited conduct clause is to make certain solutions possible. And what we have is, again, very constructive discussions with Aaron and with the rest of the community about ways to revise this clause, certainly to permit after-the-fact, non-real-time uses of it, but also to consider ways that we could enable it in real time in ways that allow the different, provides a proper allocation of the risk, make sure everyone understands where the risk is, and in fact, where the people who are operationally responsible for the risks have the high-level incentives to make sure sure they're managed. And in fact, and the key to that, again, is having a click-through agreement that really reflects those risks and how they're allocated in the terms of the RPA. In terms of accessing the TAL, going to the indemnification clause, arbitration clause, and choice of law clauses, governmental actors are often by law disabled from signing these. And Aaron has a policy that's often not well known of waiving or revising these clauses when it can be shown that the person, the governmental entity signing with them lacks the capacity to sign that. And so that is something that's not generally well known. I think that this community would be well advised to know that. And as one agency finds that out, there's no reason to reinvent the wheel. That should be shared broadly with other units in that organization, in that level of government, to make sure that that's possible. In terms of non-governmental TAL access, there is a concern that indemnification clauses poses a barrier. Well, there is a part of it that it triggers legal consultation. That's appropriate to some extent. But organizations, the other question is, even if you have the proper legal consultation, the decision whether to sign an indemnification clause is one of cost-benefit analysis by the operators. And that one of the things that we can do here, and part of it also is just frictional risk as well. We'd like to try to reduce the frictional risk as much as possible. We'd like to try to increase the benefits as much as possible and lower the costs. And if we can do that, we can get marginal implementations that are currently holding back. There'll be some who will never adopt. There's some who've already adopted. It's those people who are on the cusp. We probably can't fix the ones who will never adopt, but the ones who can, we can try to change the legal environment to make this easier. What we do when we compare the indemnification clause, actually on the validation side, what we discover is there is diversity here. AFRINIC and LACNIC have no analog to the relying party agreement whatsoever. RIPE NCC uses a disclaimer of warranties. APNIC has a no RPA, but has published terms of service that say that there has to be indemnification by any relying party. But as I just said a minute ago, in the US, terms and conditions that are posted on a website but are not clicked on by a party are not binding. So in effect, APNIC has this as an aspirational statement, but probably certainly under US law, agnostic about other areas, that's probably not going to be effective. What you see in Aaron is a fairly robust set of agreements of disclaimer warranties, indemnify, defend, hold harmless. And what you see actually, even in the APNIC one, it's just about indemnification. They don't put a duty to defend or hold harmless on there. So we have a different environment, admittedly, but a difference in the terms. When we take a look at them, what we can say is there's actually two alternative routes that can be done in the alternative or actually together. Actually, they're done together now. One is the indemnification clause. The other is the as-is disclaimer of warranties. We see this in many software contexts and security contexts elsewhere. It reduces the risk of liability for negligence, and that in fact, it does require, it may require some court proceedings. It's not a get-out-of-court-free card. Now, you can't insulate yourself from a lawsuit. Any nut can sue you at any time. But the question is, how fastly can you terminate litigation that surely should go away? There are ways to do it earlier and later. In fact, what you will see is you have to prove the contract's valid, you have to prove the scope of it. There's a certain amount that will involve some costs here. So the question is, how do we deal with this? One, it would bring, abandoning the notion of shifting from indemnification to more as is, depending on how you consider the relevance of the APNIC terms and conditions posted online, would bring Aaron in line, certainly with their explicit policies, the Aaron's RPA, and would potentially have some benefits there. And it's similar to what we do with DNS trust, root anchors, trust anchors, and other technologies in the security space. There are some other challenges, which is it will expose Aaron to some degree of risks, and in fact, they will bear costs that will largely create benefits to the larger community. There is a real risk of some litigation here, and trying to find the right way to balance that. Part of it's by reducing the risk by having operators really deploy the best practices, but part of that's just not going to be reducible at all. So what we see, again, is the RIPE example. It's an interesting one. We'll have to see where the thing we're exploring actively is the extent to which we can actually make some changes in that regard. Now, on the signing side, what we see is we get the privacy. To get the keys, the IP resource holder gets a private key, and you publish the public key where everyone can, in fact, read and confirm the ROA. To do that, you have to sign a registration services agreement. New resource holders get an RSA. Old resource holders get a legacy RSA. They have the same problems as the RPA, indemnification clause, choice of law clauses, And in fact, for governmental entities, Aaron already waives those. Again, the same solution is to make that known broadly and to have people take advantage of it. For legacy address holders, the LRSA actually contains a no property rights acknowledgement. This is an issue of some controversy that goes back a long time in this community. Our interesting point first is, before we get too involved in this, we should bear in mind that all IPv6 involves an RSA. There is no legacy holders, and RPKI is not deploying there. So I don't mean to suggest that anything we're doing is a panacea to these problems, because otherwise we'd see wide-scale RPKI deployment in IPv6. Set that to one side. We do not want to resolve this issue. What we see is the question of who the residual claimant for the IP address is logically and conceptually distinct from RPKI. And our hope with our proposal is to decouple the two issues. And to do that, we actually have one example, which is RIPE NCC has created an alternative form, which they call the Non-Member Services Agreement, which basically does not require registration or address the issue of transfer rights, is subject to other conditions, and is paid in fees at the same level as the general RIPE membership. And this is a way that RIPE has been able to decouple these two issues without and the hope is, by having this as an option, you're neither acknowledging the right nor not acknowledging the right. The goal is to make it so that they're separate, so that a separate controversy, an important one, does not affect RPKI adoption and slow it. Okay. Other legal mechanisms, they can, and I'd like to leave as much time for questions as possible, so I'll do this fast. The government actors, procurement policies of private actors, it can encourage adoption. One of these things we're seeing based on the traffic on the listserv, NANOG, your peers, are likely to be showing more interest in RPKI and expecting resolution to this, and your customers are as well. And the failure to implement this well can lead to a disconnection of your customers from service. And so I think that this is a moment technology whose moment has come, and this is something that I think that what you can see engage in some positive pushes. In Europe, AM6 has changed its policies to change unsigned routes to invalid unless you opt out. So you have certain actors in this space who are actually upping the ante for no action. The penalty for inaction could lead your route to being signed as invalid. That appears to have had some impact in RPKI adoption in Europe in ways that have potentially been beneficial, and we see things like Manners by ISOC and other actors who can lay some benefits here. The nano community also should consider the US government can include RPKI as one of its specs, either as a requirement or as a scoring criterion. Obviously, more secure routing is better for the government service. That would be potentially beneficial. Next steps, we need to build on our progress. I think this conversation has actually yielded benefits already. Something I glossed over too fast. One of the things that's actually showed up on the listserv that Aaron expressed some willingness to do is to try to find a way to work with software distributors to create click-through acceptance of the licenses. I think that would be a tremendous improvement in the environment, and we're hoping this is a direct the product of the dialogue that we're starting here and is continued on the listserv. Second, I think that we've had very productive discussions with Aaron and parts of the community about how to revise the prohibited conduct clause, and I thank all the members of the community who shared that information with us. And I do think more general acknowledgement of the exception for government entities will be very beneficial. We need to make sure that, in fact, the community understands that RIR, you have to understand how to deal with the inevitable failures, and it's proven by history. And there is a set of best practices and RFCs that talk about this that need to be internalized by the community. And then we're going to actually continue the work we're doing. We're going to look at the non-legal barriers. We're going to look at the RPKI-related agreements. We're going to look at the procurement requests. And in fact, we're looking forward to being here all week, which we will, having the conversation that will follow here, having the conversation that will follow after tomorrow's security track, and we're happy to take this to continue this dialogue as we go.
Job Snijders, NTT Communications. It seems to me that a lot of the issues you've identified would be very simply remedied if the RPA in its entirety just goes away. And it's not modified, it's not updated, it's just annulled and no longer considered part of the process. Because in comparison, GeoTrust, IANA, Komodo, GlobalSign, and many other PKI providers do not have relaying party agreements. So I would argue So what is your take on just getting rid of the RPA entirely?
So the reason we said an RPA is appropriate is that if you get rid of it altogether, the risk is that you will turn essentially Aaron into an insurer for all the liability that happens. And that is a real possibility under US law, probably to an extent that it isn't true in other areas. There's other things in the operational context, for example, other regions have less legacy space. Other regions have integrated internet routing registries that facilitate certain things about propagating information. And our belief is that the standard in many other security areas is to have an as-is disclaimer, but to be legally effective, you need a contractual agreement between the two parties. So we think an appropriate compromise, the research we've done is to set it up so that we have a contract, but it lays off the risk. It discloses the risk to everyone equitably so they can handle it appropriately.
Thank you for your feedback, but I would like to highlight that all the company names I mentioned just now are in fact American corporations, which do not require a click and agree approach. So there seems to be a disconnect in one way or another.
I think the appropriate thing for us to do is to continue this conversation tomorrow, after and at tomorrow's track.
I will yield the microphone to others.
Michael Sinatra, ESNet. Thank you very much for that presentation. That was good. The question I have is there any precedent, and I realize that this is sort of a snowball's chance in hell sort of thing, but are there any cases in the past where something like this, where you had an entity that had risk that they wanted to pass off on, you had these sort of mutual risks with indemnification clauses and things like that. Have there been any cases where the government has actually come in and said, through legislation, we will absorb that risk? In other words, we will basically say that this risk is either going to be absorbed by the government or it's not a risk that can be litigated anymore.
Absolutely.
And, is that one possibility?
It is clearly a possibility. It requires legislation. The biggest example I can give you is vaccines. Yeah. Tort liability litigated them out of existence. Also, ultralight aircraft, the things that are basically hang gliders with a lawnmower engine on them. Were litigated out of existence. And they've said, look, we're going to create a compensation fund for vaccines for people. It's funded by people who participate, fixed, quick resolution. Yes, it can be done. The question is this one of those cases?
Jeff Houston, APNIC. I'll try and be quick, and it's quite a specific question. Is Aaron's position unique insofar as Aaron issues CA certificates to other parties who then issue certificates? Are there issues with liability and consequent issues around RPAs exactly the same as Aaron's? And the other part of this is, if Aaron wasn't issuing a trust anchor, but was indeed a relying party of something like the IANA, again, would Aaron's position necessarily change? Or is this an intrinsic issue with the role of CAs and their intersection with the routing space? Is this something we all have to be aware of and understand throughout the system?
So I think that there are two kinds of CAs. There are those where you have a highly concentrated inline, no alternative service, and others where you have multiple alternatives that are a choice. And in fact, there are two forms of CAs in that world too. In fact, the original proposition was to have a single trust anchor that was global, covering all of them. For various reasons, the community chose to go a different direction where we have multiple trust anchors. So we don't have a single trust anchor. We have 5 RIR-specific trust anchors, all of which are intrinsic to routing. Do I think this is absolutely unique? No. I see DNSSEC as serving a similar role. I see other things that play similar roles. Is there a difference between this and, say, TLS? I would say yes. I mean, in the sense that there are other alternatives and other ways you can configure the network. A big part, though, of a failure is how you configure your network to respond to failure. And that part is one way to mitigate the role that the CA plays here.
I suppose you sort of subtly went off in a different direction.
Sorry.
Entities that issue CA certificates for the addresses they hold are in a unique and privileged position, whether it's an RIR or someone who's been certified as an RIR. Do we all share this problem where Aaron has taken a particular solution? Is the problem itself of liability in the RPA agreements, because everyone has to use products that I sign, even if I'm an ISP, does everyone have some aspect of the problem you're referring to?
I think the answer to that is yes.
Yes,
so
okay, thank you.
The reality is just because Aaron has policies in the Aaron region, people globally access, as relying parties, access these certificates. So absolutely. On the signing side, it's one thing, but on the validating side, absolutely.
Thank you.
Hello, John Curran, President and CEO of ARIN. Two things. First one's a question. I appreciate, Christopher and David, your study. It's wonderful to have this. You put up a slide that suggested that ARIN might consider an as-is position rather than an indemnification position. And that, obviously that's going to require some study and has some amusing implications. But even if it was as-is, is it correct that your legal assessment is that it wouldn't be binding unless it was downloaded or some other affirmative action to accept it? We'd still need to have a separate action to accept that.
Under US law, the conventional wisdom is yes.
Okay. I thought as much. I guess the second point in high level is ARIN welcomes the study. Thank you for doing it. We look forward to the conversation and the final report, the recommendations that come out of it. I've been directed to initiate a review of the report when it comes out and make recommendations promptly to improve our practices to try to do what can be done. Thank you.
Well, I appreciate that, and we look forward to working with you and the entire community on how to make a goal that we all share, which is to make the internet routing more secure, working together towards making that a reality.
Thank you.
And that's my time.